bit of a challenge, but I appreciate everybody taking time to do this. Do we have Mohsen on the line?
He had told me, he had reached out and said that he likely was not going to be able to make
it. He's got some childcare issues. His wife has gone back to work, and
oh, okay. So it wasn't
got little ones.
Was he handling that last bit of Article 4?
So my understanding is, I'm sorry.
No, yeah, actually he was, I think. So Cliff, were you going to say something?
No, I was just saying he was, and I hadn't heard he was not going to come here. So
I think he was just going to do 410 though, right? Because you did through 409.
Yep.
Yeah, so I think that was just 410. So Catherine is doing 401 to 403. I'm doing 404 to 406. And Cliff, you did 407, 408, and 409.
Yeah, okay. So can someone tell Mohsen that it would be great if he could be at the next meeting and he really needs to do 410? Okay.
Valerie, I'll work with him. I know that he had asked me that if he needed a direction to if we can even find a specific period of time, maybe we can come at the very beginning of the meeting, and we already have that meeting scheduled for June, so I should be able to work with him.
Yeah, that would be great. Yeah, I know where everybody's juggling a lot these days, so it's just I think we're just gonna have to do what we can and move forward with everything. And then for the June meeting, we've got Teresa starting with Article 5 is what I've got, basically, if we get through all the Article 4 stuff today.
Yeah, that was my understanding as well. But if I need to be flexible so Mohsen can, come into the middle of it or the end of it or the beginning of it, that's totally fine with me.
Okay. Yeah, we'll coordinate. If we need to, we'll coordinate offline then about that. I am going to have my sound off for most of the meeting because the chickens are being particularly obnoxious this morning. So I don't want to disrupt the meeting with the chicken noises. But
I could open my window and join my chicken noises with your chicken.
They could talk to each other.
Hey, it's good background noise.
I was giving a presentation for MBA a couple of weeks ago, and they were going crazy in the background. I was like, oh, so embarrassed. So when you're presenting, you can't get away from that. But I'm going to mute myself for most of this. But again, just wanted to say thank you so much. I really appreciate everybody taking the time out of their day and to do this, particularly given the crazy and frankly unprecedented situation that we find ourselves in. So with that, I'm going to turn it over to Kathy and Roberta.
Okay, good morning. I am going to start on Section 401 of the Model Act. And this corresponds to ORS 63.245 about becoming a member. So A starts at the limited liability company is to have only one member upon formation. The person becomes a member as agreed by that person and the organizer of the company. That person and the organizer may be, but need not be, different persons. If different, the organizer acts on behalf of the initial member. And then B is about if there's more than one member. So if a limited liability company is to have more than one member upon formation, those persons become members as agreed by the persons before the formation of the company. The organizer acts on behalf of the person informing the company and may be, but need not be, one of the persons. There's nothing exactly in the Oregon statute that mentions those two, but I think they make sense. And then if we go to C, this is more of what the Oregon statute is similar to. After formation of a limited liability company, a person becomes a member as provided in the operating agreement as a result of a transaction effective under Article 10, which is merger, exchange, conversion, and domestication. With the affirmative vote of consent of all the members, or as provided in Section 701A3, which is events causing dissolution. So the way the Oregon Act reads is, they say a person becomes a member of a limited liability company on the later of the date the initial articles of organization are filed, the date in the records of the limited liability company as the date the person becomes a member, Then it goes on to say, after the filing of the limited liability company's initial articles of organization, a person may be admitted as a member of the limited liability company upon compliance with the articles of organization or any operating agreement, or if neither the articles of the organization nor operating agreement provide, it says, in the case of a person acquiring a membership interest directly from the limited liability company on a consent of the majority of the members. And that's different because when we were reading the Model Act, they have an affirmative vote or consent of all the members, not a majority. And then there's B and C of the Oregon Act, which talks about assignees. And in the Model Act, they do away with the term assignees. They use the word transferee. And the Oregon statute, B and C, is actually addressed in 107 of the Model Act, which talks about what a transferee is. So 107B of the Model Act says the obligations of a limited liability company and its members to a person and the person's capacity as a transferee or as a disassociated member are governed by the operating agreement. Whereas Oregon says they can also look to the articles of organization. And then also the transferee issue is really addressed in 502 of the Model Act too, where it talks about transferees versus assignees, which section 502 of the Model Act is transfer of a transferable interest. So transfer is defined in section 102 of the Model Act, number 23, and it specifically says a transfer includes an assignment. So I don't know if how people feel about one, the consent of all the members versus consent of a majority of the members.
I like the entirety of 401 as written.
The only question I have actually is in section A. Catherine, I think you were saying that there's no corresponding provision in ORS. It seems like when we're forming entities, we don't necessarily have like a organizer consent dedicating the initial members or identifying them as we do with corporations. So I actually like this and think it makes sense in that it brings it more in line with the Corporation Act. But I think it will necessitate a change in how people advise LLCs and the documentation around that. I don't know about the other practitioners in the room.
Yeah, I agree. I think we should probably flag it for, if we're thinking about presentations and CLEs going forward. But I also like the way it's structured.
With respect to C3, where the issue of all the members, it is the disjunctive right afterwards. And in C1, as provided in the operating agreement, which could there you could have majority, so you can kind of cover it there. This is the disjunctive, so it's one of the four in C.
Yeah, and actually with I like all of the members, just because when you go to the sections I covered last time where it talks about how you amend an operating agreement, it's by a majority. let me see, what is that? Amending the agreement requires, the consent, I want to say, of a majority of the members or to take actions. If you have or only require consent of a few members, then somebody could effect a transfer to essentially gain control of an LLC. So I think the default rule of unanimity makes sense.
Any other discussion on 401?
I agree that unanimity as the default rule makes sense, and probably most operating agreements are going to deviate from the default rule of unanimity. They may not. On something like this, maybe it's 100% unanimity. So just putting in context, if there is no written operating agreement and individuals are looking to the statute for their default rule, I think in that context, particularly C3 makes sense as written.
I don't hear anybody worrying about the Oregon statute talking about, it talks a lot about the dates. When does a person become a member? And I mean, I have no particular feeling on that, as I am not a practitioner, but I wonder if that doesn't seem to be anything that people are concerned about, but I just really raise it as being something that's different.
All right, well, I think we may have set a record in getting through a section, so great job. All right, moving on to 402.
Yes, so 402 is the form of contribution. A contribution may consist of property transferred to, services performed for, or another benefit provided to the limited liability company, or an agreement to transfer property to, perform services for, or provide another benefit to the company. The analogous provision is ORS 63.170. I'm sorry, 175. And it's essentially the same, except Oregon specifically includes cash instead of including in the Model Act, property is defined to include cash, but Oregon statute specifically states consists of cash, property, services rendered, a promissory note, or other obligation to contribute cash or property or to perform services.
So I'm not seeing a specific definition of cash included in the definition of property, which is on page 10 of my printout. And it's sub 17 of the definition section.
Yeah, it says property means all property, whether real, personal, mixed or tangible or intangible, or any right or interest therein.
Right. I mean, I'm not personally concerned about this. Does anybody think it's going to cause confusion? Okay. Any discussion?
I just wanted to point out one thing that's in the comment to 402. It's in the second paragraph. This act does not contain a statute of frauds specifically applicable to promised contributions. And I wanted to contrast that with 63-181, which does, I think, have a statute of frauds for contributions. And so I view this as a change in Oregon law. I don't think I have a problem with it, but I thought we should be aware of the change and make a conscious decision about it.
Yeah, I think you mean 63.181 in the ORS. Says
Okay,
a promise by
That's what I was going to ask.
Or did I say the wrong number?
No, there is no 181.
It's 181.
Yeah, sub
right,
one.
Right. And that says it's not enforceable unless it is set out in writing and signed by the member.
Well, and I think the parallel section is the next section we're going to talk about, Cody.
Well, I understand that, but I just don't think that 403 addresses that issue, that sort of statute of frauds issue.
Right.
That statute of frauds issue in ROLCA is addressed simply in the comment to 402.
Oh, I see what you're saying. Yeah. Let's talk about, that's a good point. Let's talk about that when we get to the next section, which might be almost immediately.
Yeah, I'll weigh in here. I think we should keep ORS 63.180 sub 1 and continue the requirement for a statute of frauds on contributions. And the reason for that is, in a lot of ways, these are the default rules for the ma and pa who are putting together their business without the benefit of a lawyer. And it seems to me that requiring something to be in writing is a good thing, and it will avoid a lot of litigation over, you know, ma said pa was going to do something. So I think it's good to have that clarity that we have in ORS 63.180 sub 1.
I think the consequence, I worry the consequence of that would be most of those promises would end up being unenforceable, because I think you're right, in the ma and pa situation, most of them aren't in writing.
And I think having a clear rule that they would be unenforceable is better than having the litigation that would be created by the ambiguity of whether they're enforceable or not.
I would say that's an argument on the statute of frauds generally, though, wouldn't you say?
Teresa, do you think the best place for that is in 402, or is it better in 403, which is or whatever the equivalent is that we're going to do? Because that's liability for contributions. So which is better in terms of where you place the enforceability?
I think because right now it's in an ORS section entitled liability for contributions, I agree it should probably go into 403. Because that's where Oregon practitioners will look for it. But this is consistent with what Oregon law has been. It's an issue that ROLCA apparently chose not to address, but it's a situation where I don't think we should change existing Oregon law on the subject.
For me, it's less of an issue of giving people sort of notice that they're going to have to do a writing or it won't be enforceable. Because I think that the people that these default rules are designed for are not people who will have read the act. The people who are just winging it, and the people who are doing an oral deal and taking advantage of the LLC's flexibility. For me, I worry more about the situation where you have some kind of clever operator who's getting into business with unsophisticated people. And that's the situation, I think, where having the statute of frauds may hurt the unsophisticated person who relies on oral promise by the sophisticated party, who then gets out of having to do their end of the deal. If everybody's unsophisticated, then I think James is right that none of these promises will be enforceable because they will all be oral, or maybe they will all be written, but nobody's going to have notice of this requirement. I'm worried about when you have a disparity of knowledge and power, and that's where this could be used against somebody potentially.
Well, it's only going to be, the point is it's protective of the people who are promising to make contributions. So if unsophisticated Joe decides that he's going to promise to, sleazy operator Tim, that Joe says, I'm going to put $5,000 into your new company, but never puts it in writing. I mean, this allows Tim not to enforce that provision because it's not in writing. Whereas under ROLCA, without the statute of frauds provision, sleazy operator would be able to go into court to try and force unsophisticated Joe to pony up his $5,000. So I think this is protective of the people who could get scammed into putting money in.
As Teresa and Cody point out, it's a sword that cuts both ways. For me, it's a question of why are we ignoring a long body of law? Why does ROLCA ignore it? The Oregon statute doesn't ignore it. And so I'm in favor of probably adding back in Oregon law on this. But again, it's a sword that cuts both ways. So there's no right or wrong here.
I guess for the litigators in the room, is this something that you guys have seen actually be an issue? Because we have, the Oregon statute does have a writing requirement currently.
The Oregon statute currently has a writing requirement, yeah. And I mean, I wouldn't say that ROLCA is ignoring it. I think ROLCA is making a different policy choice to not have a writing requirement. At least, the generally applicable statute of frauds would apply, like a contribution of land. But I think often you have a for example, you might have the sweat equity partner and the financier. And often the details of what the contribution are of the sweat equity is pretty ambiguous or amorphous. And so there'll be disputes about, well, who was supposed to do this aspect of the labor? Oh, well, the financier was actually going to do certain aspects of labor, things like that. And, you're right, because we have this requirement of a writing, it's not so much of an issue. I'm not sure how it plays out in other states that don't have the statute of frauds. I ultimately don't have a very strong view on which way we should go. I'm fine keeping the Oregon statute, but I just thought we should at least think about what are the implications of changing the law in this regard.
Sure, absolutely.
Valerie, if I can add something here. There's, in the comments, statute of frauds is mentioned in a couple of places. And I apologize if someone has already pointed this one out. Second paragraph under 402 does not contain statute of fraud specifically applicable. But further back on the provisions on page 17 of the ROLCA with comments, there's a fairly long discussion, and it's in the context of operating agreements, but it really confirms the drafters are setting out no rule within ROLCA that is the statute of frauds. And looking at those comments, and then back to 402, the second paragraph, I think their approach is to let each state statute of frauds speak for itself. So if you have a situation where there's, say, an obligation to contribute real property, those, and the things that are specifically applicable under our normal statute of frauds analysis, then it's really saying let the statute of frauds be the statute of frauds. And it's realizing that in a number of commercial contexts, there's economic transactions that go on that are the statute of frauds doesn't require a writing. And so I think it's just trying to align the commerce that goes on in the LLC context with those other commercial transactions. If I read sort of the tone of what these comments are getting at. So I don't know if I have a strong feeling either way, but I think that gives us a sense of what the ROLCA drafters were thinking.
Thank you for that, Michael. Okay, any further discussion on 402 before we move on to 403 with maybe a more involved discussion of provision? Okay, so let's talk about 403 because I think this is where Oregon has incorporated the statute of frauds into its statute.
Valerie, I'm sorry, I don't want to interrupt, but where do we stand on 402? You want to wait until after 403 until we make that decision?
Well, do we need to? I mean, we can always circle back to any section.
No, I just want to make sure I have my notes right.
Yeah, no, I think we can always circle back to any section, but where this seems to have been incorporated into the current Oregon statutes is in this liability for contribution section, which is the 180 sub 1 of chapter 63 in the ORS. Kathy?
Okay, so 403A. And again, we're looking at the comparable Oregon section is 63.180. A person's obligation to make a contribution to a limited liability company is not excused by the person's death, disability, termination, or other inability to perform personally. So the way Oregon reads is the first section is a promise by a member to contribute to the limited liability company is not enforceable unless it is set out in writing and signed by a member. Then it goes on to say, except as provided in the articles of organization or any operating agreement, a member is obligated to the limited liability company to perform any enforceable promise to contribute cash or property or to perform services, even if the member is unable to perform because of death, disability, or any other reason. So I think that's essentially the same as A, except for we are not requiring, the Model Act is not requiring a writing signed by a member. The Model Act B says if a person does not fulfill an obligation to make a contribution other than money, the person is obligated at the option of the limited liability company to contribute money equal to the value of the part of the contribution which was not made. So ORS talks about the money that is in the records of the LLC company under 63-180 number 3. If the member does not make a required contribution of property or services, the member is obligated at the option of the limited liability company to contribute cash equal to the portion of the value of the contribution as stated in the limited liability company records required to be kept pursuant to ORS 63.771 that has not been made. So I don't know, do we want to discuss that now or do we want to keep going?
Well, okay, so let's put a pin in the statute of frauds issue to start with. Can we take a straw poll on, do people think, I mean, because my feeling is that this looks like a policy decision by the legislature. And so my personal preference would be that where we see a policy decision by the legislature, that we respect that. And so I would be in favor of adopting the current sub 1 of 63-180 and incorporating in right here. But do people feel strongly otherwise? And should we take a poll about this?
I feel like, I don't feel like there was momentum to undo 63-180 sub 1, so I'm fine keeping that. And, okay, you know, I'm also fine with the rest of 403 as it's drafted. And so I would sort of propose just adopting 403 as written and add something to the effect of 63-180 sub 1.
So I'd be okay with that as well.
Yeah, because it basically is pretty parallel other than that one provision, right, Kathy?
Right.
Well, Valerie, this is Kyle. Just a question. And I actually have no idea what the answer is, but do we know if the statute of frauds provision is something that the legislature expressly added, or was it part of whatever model law the prior statute was based on? That to me would make a difference in thinking about whether this is a policy decision that needs to be respected. If the policy is we're going to follow what the model act that we're basing our statute is, that's a different policy than we expressly want to have a statute of frauds provision. But
yeah, no, that's a fair point. And Cliff, you mentioned with respect to the earlier section, parallels to the Corporate Act. Do you know what the Corporate Act says with respect to contributions?
I don't.
Okay, Michael, do you happen to have at home?
To Kyle's question, the all of 63-180, as you can see, originates from the original 1993 Act. So as we've talked about previously, the 93 Act was an amalgamation of the Corporate Act and the Partnership Act and the Limited Partnership Act. So I would, I haven't looked, but I would bet that you'd see a similar provision over in the Limited Partnership Act, or maybe the predecessor there. So this is not something that the legislature has touched since the original adoption of LLCs in Oregon.
Okay, so maybe it wasn't an affirmative policy decision then.
So can I just bring something up? Because Kathy read sub 3, and there is something in sub 3 that is not in the ROLCA, which is the stated, as stated in the limited liability company records required to be kept. So I think that's another thing that we should think about, whether that's something we need to keep. Originally, I thought that's kind of like part of the statute of frauds, but it really isn't. It's really, I think, kind of it is basically saying, I think, that if you don't have the records, then you can't enforce it, I think, is what it's saying.
Or I think you can't change the value. Or current Oregon law requires these records as provided in 771. And one of the things that would be said in those records is a designation of the value of the contribution. And it's essentially, I think, locking in that value, even if, let's say, the property you promised to contribute has declined in value, you still have to give the property. You don't have to do any more than that. Or if it's increased in value, then I guess you would still be giving the property, and you lose out on that increase. But that's something that ROLCA, I forget which section it is. It's a later one that we haven't gotten to yet. But yeah, it doesn't have any equivalent of 771. Sort of something we'll have to talk about.
Just in addition, I've looked over at the Limited Partnership Act, ORS 70230, sub 1. A promise by a limited partner to contribute to the limited partnership is not enforceable unless set out in writing signed by the limited partner. So it looks like that's an exact parallel to 180 sub 1.
And I was going to add, looking at Washington law, excuse me, it appears that they're not addressing the statute of frauds issue. So it seems to me they went with the Model Act. I had sent, I believe Sandy sent these out previously. It's under RCW 25.196, liability for contribution in Washington. So it seems to me Washington is following the Model Act in terms of not requiring a writing. I'm licensed in Washington and I do form entities, but I haven't had the issue come up about something being in writing. I don't know if anybody else has.
I guess, you know, a hypothetical I'd throw out is, again, we've talked about our two individuals that form an LLC. They're going to be carpet layers. They file the articles. That's all they do. And they orally agree to each contribute $10,000 to the company. Mm-hmm. So in that context, I think that would be the kind of thing that if we were just looking at a statute of frauds issue under the Oregon statute of frauds, that oral commitment would probably be enforceable. And so I'd raise the question again, you know, if we have these beautiful operating agreements, this is not going to be an issue, but it will be for our carpet layers. And so I guess, you know, frankly, if you know, which way is justice served better in that context? So just want to give a different perspective there in terms of how a dispute might come up in this context.
I'm just looking at the revised, or it's the Uniform Partnership Act as amended in 2013 by the National Conference. It's got the identical, it's got essentially got the identical provision as R402 with the same comment that there's no statute of frauds applicable to contributions there. So at least the uniform law has changed since what Oregon adopted in you know, 20 years ago. In other words, I guess I feel free to make the policy choice. I don't think the legislature really thought this one through and made a considered decision, unlike in some of the transparency provisions.
Well, and I think Michael's point is well taken, that if you have your two carpet layers who don't have anything other than their articles of organization, what are they, what are they likely to have? So thoughts on that, anybody?
I guess I'm less worried about the two carpet layers because most likely they'll work their problems out than I am worried about the potential for, as Cody mentioned, the unscrupulous, sophisticated guy who wants to take advantage of getting a bunch of oral promises from people to contribute to his new shady venture. I almost feel like those people need more protection because otherwise they're going to end up getting sued for those contributions, probably by shady guy's bankruptcy trustee or receiver.
Well, shady guy will get in writing the contributions that his partners are going to make. He is not going to put in writing his promised contributions.
That's my experience as well, Teresa, is that the shady operator will absolutely get the unsophisticated person to sign whatever needs to be signed to make that the unsophisticated person obligated, and will make all sorts of oral agreements knowing that they're unenforceable. And even if you had a situation where, even if you didn't have the statute of frauds and somebody's trying to take advantage of an unsophisticated party by getting them to agree to something orally, you're probably gonna have a lot of defenses, despite the fact, even if you don't have a statute of frauds defense, you're probably gonna have a lot of other defenses to whatever that oral agreement was, if it was induced by fraud or any number of other things. So I tend to side, although I don't feel particularly strongly about this, I tend to side with what I think Cody's saying which is that as between whether the statute of frauds is protective or unprotective of unsophisticated parties, I tend to think that it is unprotective, and that ROLCA would be more protective of, as written, would be more protective of unsophisticated parties.
Kyle, I think you make a good point. I mean, I think it's possible to argue that the unscrupulous dealer is more protected if there's a written requirement versus if he's made a lot of fluff promises orally that don't come into the agreement because they're not in writing. I think you can make the argument that the unscrupulous player is being protected by having a writing requirement.
And I guess I'm just having a really, really hard time seeing that, because whenever you don't have a statute of frauds, what you end up with is, as Kyle mentioned, lots of defenses, lots of argument, and lots of litigation, which is full employment for lawyers, but it's not good for people. And it seems to me that having clear rules are useful to avoiding unnecessary disputes, because otherwise what will happen is we will have lots of cases about the fight, and every time we have statutes of frauds that aren't clear or don't exist, then we end up with that kind of litigation. And I'm just not sure that we are wanting to put together law that I think is going to lead to more litigation than what we already have.
I just imagine that people aren't going to choose to not file suit. Like if they've gotten to the point where they're talking to lawyers, they're thinking about suing each other, I just imagine that the statute of frauds isn't going to convince many people not to sue in the first place. And so to me, it's less about creation of litigation. It's about what are the substantive rules once you're in litigation.
But a statute of frauds will get you out of a case on summary judgment a lot faster than not having a statute of limitations and having a bunch of he said, she said stuff going on. I mean, it's the difference between being able to get rid of the case on motions and being able to have it go through a full-blown trial to be resolved.
I don't think that we're disagreeing, though, that the unsophisticated taxpayer would be disadvantaged in that situation, though, right? Not taxpayer, unsophisticated carpet layer people would be disadvantaged in that situation because effectively they'd be out on motions, right?
Well, I think that it all depends on how the fraud comes about. And really, I don't know how much of this is going to come out of fraud situations or out of simple misunderstandings where people get together and say, let's form an LLC and we'll go buy a cabin at the beach and everybody will throw in, you know, their share of the money to buy it. And Joe thinks that his share of the money to buy it is 25% of the purchase price, but it turns out that he hadn't factored on the fact that it's 25% of the purchase price plus the upkeep, plus the taxes, plus the transaction costs. And suddenly it's a lot more than he thought he was getting into. And then you have an argument about what Joe actually thought he was promising. Did he think he was promising just the 25% of the purchase price, or did he think he was promising the whole thing? And then you just end up with fights. I think if you have it in writing, you can at least eliminate a lot of the fights. And that's why I think statutes of frauds are generally a very good thing and we ought to have them.
The statute of frauds isn't going to make every agreement, isn't going to cause every agreement to be in writing. Unsophisticated people are still going to make oral agreements. And the question is whether unsophisticated people don't get the benefit of what they think they're agreeing to because they didn't know that it had to be in writing.
And I think that's a good thing for the universe if people understand they have to get it in writing or it's not worth the paper it's written on.
But do we think people are going to understand that because we have in a statute that it needs to be in writing? I mean, I guess I kind of disagree that that's going to, if the idea that it's better to have your agreements in writing has not penetrated to certain parts of society yet, I doubt that what is in this statute is going to accomplish that. But
have we devolved to a cynicism versus idealism disagreement here?
No, but I gotta say that I was really persuaded by Teresa's point. Not that, you know, people will put stuff in writing or won't put stuff in writing, but if they put stuff in writing, then the case is going to be over at summary judgment, and that would be less burden on the courts. That's kind of what convinced me.
I think
it seems to me if you're.
Go ahead.
I was just going to say, if your clients are large institutions, lenders, et cetera, they're probably going to always get everything in writing. I'm pretty persuaded by the argument about the mom and pops and what's really going to happen in reality for the majority of these small LLCs. I think from a policy perspective, that would be the outcome I would advocate for. I think the real issue for the committee, from my perspective, is whether we think the legislature has already made a policy choice by including a statute of frauds in the existing statute, or whether that was just kind of part of the whole package at the time, and so we have a little more leeway to play with it.
I mean, I could see if we could do some a bit of research on the legislative history, though I'll caution you. I've tried to do with our fellows a bit of legislative history research from that era in Oregon, and it's pretty arduous, but we can certainly try.
Well, so Sandy, Michael has this book.
Yeah.
That's basically the handbook to when we did this last time.
Okay.
You know, and I am kind of on the fence about this issue because I feel like it is a good thing from a small unsophisticated people perspective, but I see Teresa's point and Roberta's point about, you know, it being worthwhile to get stuff in writing, although I do think this becomes a cynicism versus not idealism.
Well, and I agree, Valerie. I think we're all in agreement that the best thing to do is put it in writing, certainly. But if we start from the premise that, you know, our carpet layers, they didn't put it in writing. It's not in writing. Those are the facts. What should be the default rule that controls their situation, where one put in $10,000 and the other welched on a fair handshake promise that was oral to put in that person's $10,000. Okay, so let's look to the statute. What's the default rule that controls their situation? I mean, I think that's really what we're talking about here. And you know, as James mentioned, the mom and pop businesses here that we're really talking about.
So I think Kathy had something that she wanted to say in that last volley of comments.
Oh, I was just going to say, I agree. I tend to feel that the unsophisticated person, isn't going to know about this statute. It isn't going to be protected by our writing. So I am tending to go with Roka. I was just going to give my opinion.
I just want to say real quick, I really don't mean this to be a cynical argument. I actually think the idea that people should be able to rely on handshake promises unless there's a really good reason, because most people do think that you can rely on a promise and think that it should be legally enforceable. At least that's my perception, is that people tend to think that. Clients I've had tend to think that if they've orally made a promise with a business partner, that they should be able to rely on that. So I tend to think it's good to try to enforce those, even though we all as lawyers know that when you're basing a business especially, but anything on an oral agreement as opposed to a written agreement, you are causing yourself lots of problems.
So here's what I propose. Let's take a straw poll on just whether to include a statute of frauds provision as a placeholder or whether not to go with what the Model Act is. And then I will make a note to follow up both with Michael and our law clerk to see if there's additional research on the policy decision, okay? And we can revisit this at the beginning of next session. So all in favor of going with the Model Act? 1, 2, 3, 4, 5, 6, 7, 8. Okay, so I think that carries it for purposes of just putting a pin in something right now, but let's circle back and see if there's a policy decision that was actually made here, or if it was just sort of blind adherence.
Wait, Valerie, can you tell us what the vote was? I can't tell.
Oh, sorry, it was 8 in favor of going with the Model Act, which is the majority.
If there's 16 of us on the line, that means it's 8-8.
Well, I'm not sure. I mean, we could. I mean, do you want this to be a formal vote? We could do that.
I mean, we can. Do you want to call for a formal vote?
Well,
Jeff?
I would only suggest that because we can't see. I can't tell what the outcome is.
All right, I could call the roll. We could count. I mean,
yeah, let's do it.
Right.
We could do it in the chat, and then you'd have it in writing. That's also true.
We've been doing that with the Senate. So if everyone just
and then you have it in writing.
So if you just want to put in the chat yes or no, and then there's 2 on the phone, I'll just, when you're done, I can just call those out by the phone number. That's the easiest way to do it.
Okay,
I don't know which.
Everybody knows how to access the chat?
You just click on the chat. It's on the bottom of your screen.
Chat. I don't have a chat.
Yeah,
you do.
Hover your mouse over the bottom underneath all the little pictures.
Oh, okay. You have to do the more.
And is yes for the Model Act? And okay.
Did we go with the Model?
Well, people are kind of actually, that's a good question, but it's becoming pretty clear. Really, so everyone, if everyone's able to chat, the 2 on the phone, whoever's on the phone, last 4 numbers 7663. Who is that? Last 4 numbers 7663. Are you there?
7663 is Matt with the bar. I don't vote.
Oh, okay. Sorry, Matt. Thanks. And then last 4 numbers 9527.
This is Jamie with the Secretary of State.
Oh, thanks, Jamie. It's like, I guess, do you have any?
How many people do we have that actually vote, Sandy?
We have 14 then.
Okay.
Oh, actually, yeah.
Jamie votes.
Oh, that's true. No, Jamie absolutely votes. So 15.
Yeah.
No, you're right.
I get to vote?
Yes.
Yeah, of course.
Yay. I'll say yes then.
Okay.
Okay. So you want to read off the vote count then, Sandy?
Yeah, so let's see. I'm looking for Rolka 1.
Oh, I need to vote. Did I vote?
No, you didn't.
1, 2, 3, 4, 5, 6, 7, 8, 9. I'm seeing 10 plus 1, so 11 for Rolka is what I'm seeing.
Sorry, Jeff. So
I'm with Therese on this one.
That's fine. And I think it's fine that I think it's important that we put a pin in this, but I do think that we can circle back and see if there's actual legislative history on point that addresses it. Okay.
Can I just make one comment about it? This is kind of nagging I can't.
Go ahead.
Well, I'm just saying on the criminal side, everybody, you know, it's the old adage, ignorance of the law is no excuse. So just, I know this is the civil side. It's a different world, but you know.
What are you forming LLCs for, Jeff?
But on the criminal side, you know, just because you don't know the law doesn't mean you can't violate it. And so that's part of why I tend to favor having a statute of frauds. Anyways, that's it.
That's fair. Okay, so but everybody's okay with the rest of 403, which largely mirrors the Oregon statute.
Yeah, the only issue is, as Roberta brought up, was that, right, Oregon statute points to the records of the company, whereas the ROLCA says it's the contribution, equal to the value of the contribution.
That does seem somewhat important in that the value of the contribution at what point in time. And it seems like if you are relying on LLC records, that's pinpointed, and ROLCA doesn't seem to address that issue.
Well, so we're talking about sub B, right? That last part of the sentence, equal to the value of the part of the contribution which has not been made.
I wonder if you could fix it just by saying the value of the contribution at the time made, or if you'd want to do something more similar to the current Oregon statute.
And I guess the other thing is that this is an option, right? The limited liability company doesn't have to do that, but it is at the option of the limited liability company to contribute money equal to the value of the part of the contribution which was not made.
So under Oregon law, does the limited liability company have to keep books? And if they don't, what happens?
So I think the Oregon section where that speaks to that is 63.771.
Mm-hmm.
And sub 3 is the liability for, or the lack of liability for the fifth.
So they don't have to keep records. There's no sanction for not keeping records.
Not against an individual.
I guess I would lean towards just going with the ROLCA then, since it seems that in Oregon, you know, yeah, keep records, but you don't actually have to.
Well, and I think that the situation when this comes up, right, is when there's a capital call and like 3 out of 4 people make their capital contribution. So I don't know that it's really even a timing issue, because you've said here is the contribution that we need.
But is it fair to the LLC to limit the value to the time that the obligation to make the contribution arose? Take, for example, John Doe agrees to contribute Blackacre. And at the time he agrees to contribute Blackacre, it's worth $100. And he doesn't contribute it. And 6 months later, Blackacre is now worth $125. And the LLC goes to enforce 403B. If people are saying, you know, limit it to the time that the obligation arose, then all the LLC is entitled to recover is $100. But had John Doe contributed Blackacre when he was supposed to, 6 months later, the LLC would have a real estate worth $125. So you're essentially taking $25 away from the LLC that otherwise in value it would have had if you don't limit this to the time of the contribution as opposed to the time that you seek to enforce 403B, which under my example, in theory, the LLC would be entitled to recover $125.
Well, but so if you look at current sub 3, it says that equal to the value of the contribution is stated in the limited liability company, records required to be kept, right? That has not been made. So I don't know that we're diverging from that here by going with the Model Act.
Yeah, where are people getting the timing point? I'm not.
Yeah, I'm not getting a timing point here.
Well, that's, I think Roberta raised it. We're talking about it's in the ORS, isn't it?
No.
Well, to me, that's just telling you where you look to figure out what the contribution was supposed to be, and it's providing a presumption that it's what the LLC says it was, as opposed to just open to wide open proof. I don't see it as imposing a timing.
Yeah, so you'd still have on the currently the records of the entity would say John whatever agrees to contribute Blackacre worth $100. You know.
Yeah, okay, but at the time of the contribution, Blackacre would be $100.
Yeah,
but
the $25 additional, you'd still be fighting over that. You wouldn't automatically just be getting that, because you'd say your capital contribution was fixed at the date that it was the call was made.
Right, but again, then the value goes up and you try to enforce the capital contribution later. Are you saying that 403B allows you to capture the extra 25?
No.
It does if you read the comments. The comment to subsection B has a hypothetical example where the agreement was that the person would contribute property worth 150, and then it gives one example where it turns out that the property is only worth 75, and the LLC can go sue the person to collect the 150. And then they give a second example where the property turns out being worth 225, and it allows the LLC to sue either for the 150 or for the 225 at its election. So this is giving the LLC the maximum choice about getting the most it can for the property.
See, and that's where records could be problematic, because if at the time of the contribution, the record reflected that it was worth, using the numbers in this example, 150, but at the time you seek to enforce, it's 225, and you get this example that says you can go after both, or one or the other.
It says you can elect to go after one or the other, but you can choose to go after the higher number. I think this is going to be used primarily not for proposed contributions of cash, because cash doesn't fluctuate much in value, other than the total value of money. It's going to be used for contributions of intellectual property or real estate or something where the value is within a range and the parties agree on what that value is for purposes of the contribution to the LLC. So if what you're contributing is a patent, and you all agree that the patent is worth $100,000, even though nobody really knows what it's worth.
Right.
It means that the LLC gets to have the benefit of the bargain if it turns out to be worth more and the person doesn't contribute it, but isn't stuck with the loss if it turns out that it's worth less. This is an LLC friendly choice. I don't have a strong feeling either way as to which side we ought to choose for. But it is clearly an LLC friendly choice.
Well, the LLC is the non-breaching.
Sorry, good. It's also friendly to the other parties involved in the transaction, right? Because they've agreed to contribute what they believe to be equivalent value, or what everybody has agreed to be equivalent value, and then they strike oil on Blackacre, and suddenly, Blackacre is worth a lot more. I mean,
the point that I think I was getting at is Roberta raised the question of the ORS has, as stated in the limited liability company records. I think I'm favoring not adding that into ROLCA because of this discussion and the fact that you want to have this, or there's this LLC friendly choice based on facts and circumstances.
I think all that Oregon language adds is that if you're going to make a determination about what the value is in advance, that you have to put it in your LLC records, or then you don't get to enforce it. This just says you don't have to put it in your LLC records. You can enforce it otherwise. So I tend to agree that I would go with the ROLCA language on this, because I'm not hearing that there are requirements to keep LLC records in the first place.
Well, there's no enforcement.
More eloquently stated, Teresa, than I did. I agree with you.
Before the record, if anybody's listening to this ever in perpetuity, LLCs should keep records.
And put things in writing.
Yes, that too. Okay, any other discussion on 403?
I suggest we adopt it with the caveat we already voted on.
Yeah. Okay. So Kathy, do you have 404? Does Roberta have 404?
I do.
Roberta does. Yeah.
Okay, why don't we take a 10-minute break and allow people to go get water and stuff, and then come back at, I have 10:03 right now, so come back at 10:15 ish.
All right, I'll pause the recording. I'll be back 10:15.
Okay.
Or charging order in effect under 503. The notes following 404 are extremely taxy. So the comment talks about how past Uniform Unincorporated Entity Acts and many current LLC Acts provide default rules for allocation of profits. And UPA 1997 even provided a default structure for maintaining capital accounts. For the following reasons, this act provides only a default rule for shares in distributions. And then it goes on to talk about how the rules for maintenance of capital accounts can be very complex. Anyway, I have, and the corresponding ORS provision is section 63-195, and that is entitled Allocation of Interim Distributions. And it talks about how distributions of cash or other assets of a limited liability company before the dissolution and winding up shall be allocated among the members and among classes of members in the manner provided in the Articles of Organization or any operating agreement. If neither the Articles of Organization nor any operating agreement provides for such allocations, such distributions shall be allocated among the members in proportion to their right to share in the profits of the limited liability company. So contrast ROLCA in equal shares with the ORS in proportion to the share of the profits of the limited liability company. Washington statute says that distributions will be made, and the corresponding section is 25.15.206, says that distributions are made in proportion to the agreed value of contributions made and contributions not to be made. And the Delaware statute, which is section 18-504, says essentially the same thing as the Washington statute. And what I remembered when Kathy and I were talking about this earlier this week is this relates to the Treasury regulations for partners interested in a partnership, which is essentially the rule that applies if a special tax allocation is not respected because it doesn't have substantial economic effect. And so if a tax allocation does not have substantial economic effect, then the allocations will be reallocated in accordance with the partner's interest in the partnership. Now, before 2008, this default rule in the regulations, which is under 1.704-1B3, you love this, don't you? I can see you guys look like you look like my Stu's like, what?
I think everybody else's eyes glaze over. I'm like, oh, I love this. This makes me so happy.
The default rule in the Treasury regulations was equal shares. So this might come as a shock if you have LLC members, maybe one of them contributed 80%. So one of them contributed 80,000, the other contributed 20,000, but they're two members, right? So under this former rule in the Treasury regulations and the rule in ROLCA, that would mean that on dissolution, they'd each get 50-50. This might be a bit of a shock to the one who put in 80%. Now the Treasury regulations have changed. Now they say something different. Now what they say is the factors considered in determining the partner's interest in the partnership, this is the code, is... I
do like the dramatic reading of the Treasury regulation.
Now it says, in determining a partner's interest in the partnership, the following factors are among those which will be considered. A, the partner's relative contributions to the partnership. That sounds like the Washington statute and the Delaware statute. B, the interest of the partners in the economic profits and losses. That sounds like the Oregon statute. C, the interest in the partners in cash flow. D, the rights of the partners in distributions of capital on liquidation. Okay, but I think the Treasury regulations were amended sensibly because equal shares does not make any sense. Equal shares seems to just mean if you have two partners, it's 50-50. So I don't really advise going with the RLCA language for that. It doesn't matter to me whether we go with the Oregon statute, which may have been carefully considered, saying allocated in proportion to their share of the profits, or the Washington and Delaware statutes, which say in proportion to the agreed value of contributions made. But I do not think that equal shares is a great idea, even though you can read the comments and basically the comments say, oh, tax law is so hard, let's just never mind.
I don't know much about tax law. One question I had, and maybe this just is evidencing my ignorance about this stuff, is when I read 195 and it said that the default rule is to allocate distributions in proportion to their right to share in the profits, I had assumed that that was essentially a reference to 185, and 185.2 says that if you haven't agreed otherwise, profits and losses shall be allocated among all the members equally. And so I had assumed, or I guess my understanding was that RLCA did not change Oregon law in this regard. But am I misunderstanding what 195 is talking about then?
I don't think I can answer that.
Or I mean, I guess I just didn't know what it meant in 195 to say that they should be allocated among the members in proportion to their right to share in the profits. Because 185 talks about how you allocate profits and losses. And so maybe we want to make a change, but I had understood RLCA to not make a change from current Oregon law.
Well, you may be right about that. You may be right about that, but even so, is it a good idea?
Right, yeah, no, I just.
But you may be right about that, because I did not look at 185.
Well, I take it this is subject to the default provision
It's a
in
default
RLCA,
rule.
which is that you can always vary this by the
Absolutely.
operating agreement.
Yeah.
It's a default rule, yes.
This is just going to apply to the unsophisticated carpet layers who are putting together their business to start from.
Right. So I think the question is, are the carpet layers better? I guess, so what Cody says is that the carpet layers are not any better protected by the Oregon statute, but I guess there's still a question, would they be better protected by language like in the Washington statute?
Well, then don't you get into the problem of, it's easy when you're talking about somebody puts in 80,000 in cash versus 20,000 in cash. I think where you see this more commonly is somebody puts in 80,000 of cash and somebody puts in sweat equity. And it's very hard to value that. Mm-hmm. And so it seems to me that if we're going with default rules for the people who aren't writing operating agreements, equal is probably as good an answer as any other answer.
Well, what the statute, the Washington statute says, distributions made in proportion to the agreed value of contributions made and any contributions required to be made but not yet made.
And I think the problem with that is you have to say, did anybody agree on the value of the sweat equity and what was that agreement?
Right. I don't know what the ultimate effect is necessarily. I haven't thought about it yet, but Washington and Delaware are different in the sense that, for one, Washington counts the promised but unrealized contributions, whereas Delaware doesn't.
That's true.
And then Delaware seems to have it's as stated in the records of the LLC, which is, I don't know whether they retained some kind of ORS 63771 list of records the LLC must maintain, which RLCA doesn't have. And it's kind of interesting that Washington and Delaware both seem to have totally rejected the RLCA on this issue, because when you look at your chart that you created, their statutes read super similar ultimately to what we currently have, at least in the initial framing of it.
And I know someone said, maybe last meeting, that Washington has adopted their LLC statute after RULCA, and Oregon's is sort of pre the revisions. Am I remembering that correctly?
That's right.
So,
can you tell me what I'm curious about the transactional people, and obviously the true unsophisticated folks aren't coming to you anyway, but do they always have, or do people have this description of, you know, the operating agreement says here's what the contributions are and what their values are? That's like, I assume that's standard operating procedure when you create an operating agreement.
Mm-hmm.
Yes.
Generally so, but I guess one of the complications here, what happens when you have hookups? For example, one member comes in, contributes real property worth $100,000 at the time of formation of the LLC, and 10 years go by and he brings another partner in when the real property is worth $1 million and the new member puts in 100,000. Are they then under this essentially entitled to split all the profits, or what would happen with under this?
Yeah, I mean, that's why I like the idea of tying it to positive capital account balances. What do you think of that idea? Because I think that tracks. What?
It's just super complicated. I know.
It's not that.
Roberta, you don't think it is?
Well, I mean, with revaluations, it can be. With rebooking, it can be complicated.
Yeah, but you know, the concept of a capital account is that it reflects the partner's relationship to each other. I mean, it's doesn't
their economic agreement. Yeah,
right. It's divorced from basis, right? And I think a lot of people who don't understand this think that it's tied to basis. But I like the idea better of having it be tied to positive capital account balance, because that reflects, you know, and you have a measure of that at any given time too.
And what if everybody's capital accounts have been driven down to zero?
Well.
And what if, as happens also often, capital accounts are not properly maintained?
That does.
Aren't we?
How many times do you run into that scenario?
And we're really dealing with the unsophisticated person here. Frankly, most sophisticated individuals don't understand capital accounts.
Right. This is, I mean, I think this is a default rule, so it's basically only going to apply to people who don't have an operating agreement, essentially. Who therefore don't have capital accounts.
No,
I mean,
you always have capital accounts. It's
well, I guess I would point out that our carpet layers don't even know what a capital account is.
Yeah.
Jay probably does though. You know, it's something you can reconstruct. But you know, I don't like the idea of equal either.
Well,
and actually, what if it's a LLC taxed as a corporation?
What?
They'd like to be taxed. LLC electing to be taxed as a corporation.
Then they're not under this act, are they?
They're not under the act for tax purposes, so they're not tracking the same.
But wait, they're still under
LLC.
But they're still under the act.
They're a state law LLC.
Yeah, they're still a state law LLC.
Yeah.
Exactly.
Exactly, but they wouldn't have capital accounts, right?
Fair.
And the distribution would still have to have some default that would be different, not capital accounts, then you're saying?
I mean, you could tie it to the entity's inside basis and each member's contribution, but I think that would make an even bigger mess.
Well, I think I just am, I'm not happy with equal shares, because I think that may not be consistent even with the understanding of the carpet layers. And I want to look at that 63-185. If neither the articles of incorporation, then profits and losses shall be allocated among all the members equally. I wonder if that actually happens though. And I guess this is, I mean, if you had, even if you had an informal agreement, but they understood that, at least when they went into the agreement, that they were not equal members, right? They probably wouldn't allocate the profits and losses equally if they knew, if they just thought, oh, well, I'm an 80% member and you're a 20% member. We never wrote anything down, but we understand that. But then when
their operating agreement can be oral.
Yeah.
That's true. In which case, then the distributions allocated in proportion to the rights to share in the profits based on the oral agreement would be respected under the ORS language,
right,
as a default.
This is one where I think there's some wisdom in our ORS here. I look at the Washington statute and the language about agreed value of contributions. Well, sometimes, you know, that's in an unsophisticated, particularly in an oral environment, there's nothing that indicates the agreed value of the property unless it's cash.
Do we have any idea why the state of Washington didn't follow ROLCA on this?
I'm sending an email to Brian to figure that out because I'm somewhat perplexed because for the same reasons I think Roberta doesn't like just equal distributions. I didn't like equal say in the management of the company. If you got one person who contributed 90% of the assets and two other members who collectively own 10%, yet the two members can outvote the 90% investor. It didn't seem fair to me, but they essentially followed the RULCA guides and didn't go to any of these other options, but here they did. So it just seems inconsistent.
Yeah, and I just would like to see at least one of the options that was in the Treasury regs for defining partners' interest in a partnership. I mean, I think because it did formerly used to be equal, and I think that maybe that just had an interim effect, right? That, oh, you better put something in your agreement or this is what's going to happen. And I'm not sure that that's what we want to follow. And then the Treasury regs changed it and said, no, we're going to look at these different factors, right, in determining the partner's interest in the partnership. One of them is share in economic profits. One of them is relative contributions. You know, and economic profits seems to be what's in the Oregon statute, and contributions are what's in Washington and Delaware. And so I just have a concern about equal shares.
I think that the idea of the proportion of their right to share in the profits makes sense. But I also think then that we need to have some, I guess, equivalent of 185 then that defines what is the default rule about the profit sharing in the absence of agreement. There probably always is going to be agreement on that, even among the most unsophisticated parties, but you still need a default rule, which under current Oregon law, as I read it, is equal allocation.
And I don't know if there, I haven't looked at so closely whether there's something in RULCA that would be defining share of profits, or that seems to me.
I wonder if read together though, you know, ORS 623, 185 and 190 get us to the point of RULCA, right?
Well, that's what I think they do.
I think Cody's right about that.
Yeah. You
But
know,
on the other hand, if you have the unsophisticated business partners and they know how they are sharing profits and losses because that's what they've been doing, even though they don't have a written agreement, then maybe when they come to dissolution, they may not be as getting along as well. And then you're at, oh, equal shares. Oh, we don't have an agreement. Oh, there it is.
So I guess as I read Oregon, it sort of does a two-step process. It first says, here's how profit sharing works. And then distributions work by the profit sharing mechanism. Right. And then it goes on to define the profit sharing mechanism as equal. And I'm wondering, you know, in the case of the unsophisticated people, you know, they may have an agreement about profit sharing, or we're going to distribute according to the profit, or according to our right to share in profits. But then are they ostensibly not going to define how that profit sharing works? I would think that that's the thing they actually really do define, is how profit sharing is going to work. And then maybe the thing they aren't defining is distributions.
Right.
I guess in other words, isn't it implicit that anyone who agrees, oh, you're 80, I'm 20, so I'm going to get 20% of the distributions, you're going to get 80%. isn't that going to be something that they're going to have agreed on, even if it's oral or by conduct?
Well, I think that under the Oregon statute, and I think Michael pointed this out, the operating agreement can be oral. So it's not like you have to have a written agreement saying we're going to allocate the profits 80-20. And I can see, although I don't practice in this area, so I defer to those who do, that there might be in an ongoing business allocation of profits and losses, but maybe they weren't thinking far enough ahead to what happens when the business dissolves.
But this is all about what happens before dissolution, right?
Yeah.
We're not talking about what happens at dissolution.
They have to have capital accounts at distribution.
You know, there's another thing I want to add that adds to the complexity of this, which is there's obviously, particularly in the tax world, a distinction between allocations and distributions. Mm-hmm. And ORS covers both. And 185 says if it's not stated, the allocation is equal. And then 195 says per profits. And so it kind of falls back to the allocation. But when you get into the world of taxes, and one of the huge benefits of partnerships and LLCs that are taxes partnerships is allocations and distributions don't have to follow each other. Like in an S corporation, for example, you have to be pro rata or you're going to lose your election. That's one of the negatives to the corporations. And with the partnerships, one of the benefits is allocations and distributions don't have to line up. So one thing I want to inject in here is I noticed that ROLCA doesn't have a default rule for allocations. It just has a default rule for distributions. And so I tend to favor the 185 and 195 dichotomy for all the reasons stated above, and also to add the fact that I think there should be a default rule for allocations.
Well, I think the default rule is encapsulated within this rule, you know, in that to the extent it's not stated otherwise, you're going to be sharing, you know, the cash and the non-cash attributes on an annual basis equally.
But again, it talks about 404A, talks about really just distributions.
Yeah, what's the definition?
That's a good question.
Definition of distribution?
Yeah, it's on page 12.
Does it include allocations?
That's what I'm looking at.
Because I mean, while you're looking at it, I'm kind of getting the feeling that ROLCA is really ignoring in many respects the tax law and the fact that one of the huge benefits of
Jeff,
one of the huge benefits of partnerships and LLC's taxes partnerships is the fact that you can have non-pro rata distribution.
But Jeff, you're never going to have a special allocation unless you have a written agreement.
No, I agree with that, but I just feel like, why is it silent on allocations, a default rule for allocations as well? And I know what Valerie is saying, it's sort of implicit in 404A, and she's looking at distribution. And if the word distribution covers the allocations, okay, but if not, I feel like there's just there's a missing default rule.
I don't feel like 195 is using allocation in the tax sense of the word. I feel like it's using it in the more common Merriam-Webster sense of the word.
Valerie, if I can make a point, and Jeff, kind of getting at what the question you're raising. Page 92, this is the second comment right at the top of the page. It's saying tax income and loss is allocated to partners according to partners' economic interest in the LLC, and these interests are based on distributions that would be made to partners on liquidation of the LLC. By including default distribution provisions, the Act includes the information necessary to make these tax determinations. To the extent the tax law allows partners to make further tax elections or satisfy alternative safe harbors, the partners may look to the tax law for guidance and include necessary provisions of their agreements. So I think that comment is instructive to the point that you were raising, Jeff. I don't know where that takes us, but they were silent on purpose, that they really see, I guess that they see the allocation comes out of the partner's economic interest in the partnership, and they really look to the distribution structure as being determinative of that, which I think in a lot of respects, you know, when I put my tax lawyer hat on, that's counterintuitive. We often think of the allocation of profits and losses as the bedrock that leads us to the distribution structure. I mean, that's kind of how we tend to analyze this, and this does turn that around a bit.
Well, I think though, Michael, I think that the paragraph that you're talking about, I think that, you know, the bullet point first sentence, I think the second sentence is subordinate to the first sentence, so that it is a continuation of the some people argue thing, you know, and they're just punting on it.
And I don't necessarily agree with that third sentence. By including default distribution provisions, the Act includes the information necessary to make those tax determinations. Yeah, I don't think that's correct.
Yeah, I mean, I agree. I look at it backwards. I look to the allocation first and then the distributions to the second. So I agree.
We're throwing in our tax lawyer bias on that, which I don't know if that's a bad thing, but
that's why we're here.
Yeah.
I mean, I guess the question is, what should the default rule be, right?
Well, let's go back to that. If we like 195, then, and I think Cody said this earlier, the non-tax lawyer, very good, Cody, you almost need 185.
That's not patronizing at all.
Oh, I'm sorry. Didn't mean that. Didn't mean it that way. I'm just saying that if you kind of go the approach of 195, you almost need to include 185. It just feels like they go hand in hand.
I agree, Jeff. I think the 195, by looking to profits, well, okay, in ORS, where do we find profits? And you got to go back to 185 to find that.
Yeah, because that sets the default rule of profits, and then that determines, once the default rule is set, then you know the answer under 195, because it's based on profits. So you need a default rule for profits, determining profits. And I'm with Roberta. I don't like at all what's in ROLCA, and I tend to favor the ORS approach.
Although I think Cody is actually correct that if you sort of read them both together, you do get to the ROLCA approach, but except that you pull out the possibility of altering it via an oral operating agreement, which I think is important if we're considering the carpet layers.
Yeah, and I would imagine that, you know, what are the key things that the carpet layers are going to do when they form this company? They're going to agree, I think, on what they're giving to it and what they're getting out of it. I would imagine it's extremely rare that you actually have a case where anyone who has formed an LLC hasn't reached an agreement on what they're going to get in terms of the distributions. So I imagine that whatever default rule we come up with is going to be applying to virtually no one. Although I imagine, you know, with oral operating agreements, you may have litigation from time to time, or at least disputes over what was the agreement as to profit sharing when it's not written down.
Yeah, but I think in ROLCA, it's a default rule. So to alter ROLCA, well, actually, I'm not sure the answer to this. So to alter ROLCA, does it have to be a written rule, or it could be an oral rule? It
could be oral. It just has to be that you agreed otherwise in your operating agreement. Your operating agreement can be a mix of oral conduct and written. And none of it has to be written down. It doesn't even have to be an oral agreement. It can just be the last 3 years we divided up the profits this way, and that's evidence of what your agreement was.
So maybe we're fine with ROLCA then in that event, because if in ROLCA you can alter the default rule by an oral agreement or a course of conduct, then maybe we're fine.
Right, and I mean, the ORS is the same in that regard. You know, it says, first of all, we're going to do it the way you agreed, and then if you didn't agree otherwise, we're going to do it equally.
Yeah.
So I have a question to Christy, because you're dealing with folks who are maybe less sophisticated, I mean, what are you seeing as far as people's expectations in this area?
Right, so in terms of, oops, I'll put my video on here.
Yep, I can hear you.
Okay, great. So in terms of the expectations is, we actually, in the clinic, we do have things in writing. So we do set the allocations according to the wishes of the members of the LLC. However, for those who come in to talk with us initially, their expectations are really what they're just agreeing orally. And if someone was 80-20, that would be their expectation in terms of distributions and allocation of profits and losses.
So I think that gets to your point, Cody, about how if they don't have an operating agreement, they may still have a lot of the functional parts of an operating agreement.
I don't really have a preferred solution as between ROLCA or maintaining some variation of 185 and 195. I just was trying to understand ultimately in the end how they differ. And, you know, and I don't know tax law. So in terms of what you need to do to make the IRS happy, I defer to all of you.
You have to have it in writing.
Yes, anytime you want to diverge.
Or it goes equal shares.
Well, no, it doesn't go equal shares. It goes factors, right? Factors including share of profits, including contributions.
I mean, could we expressly adopt the Treasury regulation factors?
Let me get them up again if we want to. I can type them into the chat if you want to look at them. That'll be fun. Okay.
I mean, we're just talking about a default rule that I think, I guess I'm curious if anyone disagrees with the notion that hardly anyone is going to be subject to the default rule because they will have agreed on some form of profit sharing.
Right. I mean, that's sort of where I'm looping back to RULCA on this, because I do like the statutes that we have currently, but I don't know that someone who had an agreement about what profits were and how they're going to split profits, you know, that would be part of the discussion, right? If you were actually going to end up fighting about this.
I tend to agree, Cody, that I think our carpet layers, if they're not going to agree on anything, I think they're going to agree on what are we putting in, what are we getting out. And also a lot of these things, they're going, even with no operating agreement in this oral thing, by the time they end up doing their first tax return, you know, an accountant meets with them and they figure all these things out, it tends to establish a written record and a course of conduct as they maybe formalize their internal accounting and then tax reporting. So I think it's unlikely that in most cases, even without a written operating agreement, that this is going to be much of an issue.
Right. I mean, the only thing I can see being an issue is if you had, for example, an IRS audit that differed from, that resulted in a different answer from what the taxpayers thought, you know, and if you look at the factors that Roberta's typed in on the side, the only way it could really differ would be if you had you know, variation, like they say that, oh, this is our economic interest, and IRS says, no, here's your relative contributions, right? It would fall out within the first couple of factors there, I think.
We need to purposefully keep this a little broad because these aren't going to be all partnerships and bound to partnership tax law. Some will be, as we've already discussed, corporations or taxes corporations.
But they would have, they'd be governed by their own, you know, shareholder agreements. To the extent they're making elections to be treated as corporations, they're going to have bylaws and shareholder agreements and stuff like that, right? Because I don't think your average carpet layer is going to be doing that.
No, I mean, it's still, it's an LLC, right? So you're still going to have an operating agreement.
It's a state law LLC, right?
Right, but you'll have,
yeah.
I mean, you're going to get to the same point, I think, right?
And I think if you're sophisticated enough to make the check the box election to be taxed as a corporation when you're a state law LLC, you probably have some level of advice that you're seeking and some level of counsel.
But it could be just that bookkeeper in some rural community who's putting that together.
Who took some CPE and yeah, they took a CPE. Hey, there's these check the box regs. Let's do this.
So
never happens.
So I guess if you have, so let's say that you do have an LLC that's elected corporate treatment, and you have your 2 carpet layers. How would deviating from ROLCA have a negative impact on them? In this,
so and what I guess I'm advocating for is maintaining consistency with ROLCA.
Yeah.
Is adopting something like the partnership tax regs into the statute or proposing.
Yeah, and I actually agree with that too. And also, I mean, even under the tax regs, these are factors to be considered. Right. So even if you were in an audit, I don't think you really can know how it would come out. So I think I'm fine with ROLCA after having raised this issue. I'm fine with it.
Yeah, no, I agree. I am also fine with ROLCA. Does anybody have any disagreement after that long discussion? Long and ultimately fun discussion. All right, good. I think we're at a consensus to adopt 404.
At least 404A, because
404A, yeah.
That's all we did.
All right. Yay,
oh my gosh. Okay, 404B. A person has a right to distribution before the dissolution and winding up the limited liability company. Only if the company decides to make an interim distribution, a person's disassociation does not entitle the person to a distribution.
I like that rule.
Yeah, and this is the corollary to that is ORS 63.200, and that's the right to interim distributions, and it's essentially similar. And bear in mind that 404B is a default provision. So what the ORS says except as provided in 63.205 to 63.235, which I think we've already looked at actually. A member is entitled to receive distributions before the member's withdrawal and before the dissolution and winding up the limited liability company to the extent and at times or upon the occurrence of events specified in the Articles of Organization or any other operating agreement. So basically it's cited, it's a sort of, the ORS is kind of stated in the positive, and the ROLCA is stated kind of in the negative, but it doesn't, essentially they're the same. Mm-hmm. ROLCA does add a person's disassociation does not entitle a person to a distribution. And I don't see a parallel to that in ORS, but I think it sort of makes sense. So if someone else knows a parallel to that in the ORS, I would be happy to look at it, but I was not able to find it. And the comments to ROLCA say that the second sentence of this subsection accords with section 603A3. Upon disassociation, a person is treated as a mere transferee of its own transferable interests, and it is a default rule.
Yeah, I think that's different, but I like it, so. And I don't know that it directly contradicts anything that we currently have. concerns?
I'm just looking at 603. I'm trying to find 603. Okay. So 603 is the effect of disassociation. There probably is an ORS parallel to that.
I think some of these provisions about talking about someone owning something solely as a transferee are going to be relevant to the discussion we're going to end up having in my sections about what rights and a transferee who is involuntary as to the existing member. In other words, a bankruptcy trustee, an executing creditor, something like that is going to have with respect to the company. So I think that issue is going to relate to some of the things I'll be talking about in connection with Section 5.
Yeah, I think that's right. And so 63.205 and 63.209 talk about voluntary withdrawal of a member and expulsion of a member. But they're not exactly parallel.
I think what this basically says when you get down to it is when one of your members files bankruptcy, a bankruptcy trustee who it takes over their rights to receive income does not have the ability to go to the LLC and demand that they make a distribution. Mm-hmm. That's probably the right rule.
Yeah. Yeah.
So I'm good with the language. I think, we can think back on it when we come on to what we're going to talk about in terms of execution on membership interests and other really fun topics like that. But I don't think that one member should be able to compel the entity to make distributions that may not be in the best interest of the entity to make at that time.
Right. No, I agree.
Right.
With that,
yeah. So I think that
I was going to say that's very consistent with charging orders, the whole concept of charging orders and liens against membership interest. So I agree. I don't have a problem with this sentence.
Yeah, and frankly, it sort of parallels language that we tend to incorporate into our standard agreements anyhow, under the current law. So, but I think I put a note next to section 603 just to circle back to 404B when we're there. But does anybody have any other concerns about 404? Or are we moving on to C?
Let's move on to C if nobody else wants to talk about it. Okay. C is a person does not have the right to demand or receive a distribution from a limited liability company in any form other than money, except as provided in section 707D. A company may distribute an asset in kind only if each part of the asset is fungible with each other part, and such person receives a percentage of the asset equal in value to a person's share of distributions. So fungible, that's, yeah, like I always tell my students, you can't spell fungible without fun.
You really tell your students that?
Of course I do, and they laugh because, they have to. So, I mean, there's not that much that is fungible. Right? I mean, are we talking about a farming thing and there's grain in a silo? It's like fungibly distribute however many bushels of corn? I don't know.
No, we're talking about cannabis businesses.
That's not fungible. I mean, you've got lots of different things. Maui Wowie.
I would not be surprised that some of those businesses are formed on the basis that people get a certain share of product that's produced.
But the product is not fungible, at least according to what I read. There's lots of different strains and they're good for other things. So anyway, there it is.
I think the parallel is 63-219, right?
Yes, it is. Correct. Thank you. And it is really very parallel. So,
yeah.
And except ORS uses the word cash instead of money, but I think that's fine. Also, ORS does not talk about fungibility. So, ORS, let's see. No member may be, this is ORS 63.219.2. No member may be compelled to accept a distribution of any asset in kind from a limited liability company to the extent that the percentage of the asset distributed to the member exceeds a percentage of that asset, which is equal to the percentage in which the member shares in operating or liquidating distributions, as the case may be, from the limited liability company. Whew.
But again, this is the default rule, right?
Yeah. Is this?
Yeah.
Yes, this is definitely. We're still in the default rules.
In the articles.
Mm-hmm.
Yeah. So you could say that, you know, the managers may determine what assets get distributed out if there's an in-kind distribution.
Right.
To deviate from it.
Yeah, and I think that if we're protecting the carpet layers, I think that RULCA is fine, even though it does say fungible.
Well,
I like RULCA.
Doesn't RULCA add the fungible requirement is sort of additional requirement, sort of there's the percentage requirement, but also the assets, the asset has to be fungible.
Yeah, otherwise you have to.
I'm still not totally sure what that means, whereas ORS 63.219.2 only deals with the percentage issue.
Right, but so let's say you had Blackacre again, and Blackacre is not fungible with Whiteacre, obviously, right? And so instead of distributing Blackacre to party A and Whiteacre to party B, you would distribute 50% of each of them to the two parties. I mean, I think that's where it's going with this.
That's not fungible either, though. I mean,
50%. So if you are each, I mean, it's the aggregate concept though, right? Where you say, okay, I own 50% of this asset in partnership form or LLC form, and then you're going to distribute it out to me, and I'll own it 50% in my individual name.
No, I understand. I understand what you're saying, but that's still not fungible because. I mean, if you hold it, I suppose if you hold as tenants in common, it is fungible. But I think really the practical effect of RULCA is that you're going to have to sell the property and distribute the cash.
Yeah, which is not a bad answer.
No, it's not a bad answer.
You own it as a tick, which is just, you know, the real estate people may have some thoughts about that, right? If they're trying to do certain transactions.
Yeah, well, no, I don't agree. That's not a bad result because, you know, if you sell Blackacre, there's a tax bill. If you distribute Blackacre, there may not be a tax bill. So,
right.
So I'm not sure.
Well, you should provide for it.
Right. Okay. In the operating agreement, but I'm just saying, I'm not sure I like the default of, well, just sell it because that creates a tax bill that, you know, one of the reasons people, particularly with real estate, are using LLC's taxes partnership is because you can avoid that tax bill. You put that real estate in the corporation and liquidate or distribute and it's taxable.
Well, I mean, this is the whole drop and swap thing though, right?
Well, that's 1031. That's a limited application. It's 1031.
I know, but that's the thing is that you have a partnership interest, and you're basically the only way you're going to get to something that's fungible is if you're doing, as Roberta said, and you're taking a common interest in, you know, the entity proportionate to your membership interest. I don't have a problem with the way RULCA's drafted because I think that it's a good answer for our carpet layers. You know, and it's not a bad answer for other people who can modify it by agreement.
Can somebody give me an example of a non-fungible asset? And what I mean is, Valerie, earlier you talked about Blackacre and Whiteacre, but when I look at this language, it's talking about an individual asset, not two assets. Give one to A, give the other to B.
Yeah.
The asset itself, so a single piece of property, has to be fungible. Again, I can't figure out what is an asset that's not fungible.
No, the answer is, what is an asset that everything is not fungible.
Everything's non-fungible.
Practically nothing is fungible. The only things that are fungible are cash, which is already in there.
Right.
Or things like commodities and commodities can be fungible, right? So you could have corn in a silo. Okay, we put 100 bushels of corn in a silo. Now we're liquidating, and you get 50 bushels and I get 50 bushels. I mean, it doesn't matter. The individual grains of corn, although they may be actually biologically slightly different, it doesn't matter because they're legally fungible.
Well, but Roberta, how if you take Blackacre and you have two owners and you distribute it 50-50 to each as tenants in common? Isn't that the same results as the corn? Because they each have a 50% tenancy in common interest in the same property.
That's probably, Jeff, you could probably do that.
Jeff, and I don't, this is not heavy duty legal research, but I did, there's at least one source here, according to Mr. Google, that says that real estate is not a fungible commodity. The basic rules of law and economics recognize that all real estate is unique and thus has no interchangeable substitute. Hence, the remedy at law for disputes of real estate transactions is specific performance, not substitution. In short, real estate is not a fungible commodity.
But you could distribute a tenancy in common. You could, because that is an undivided interest in the whole, right? You could do that. Of course, that's probably not going to be what the parties want. If they're dissolving their organization, they probably want to go their separate ways. And so then you could do that, and then you could have a partition action, right? Which would either be a partition by sale, or it could be a partition in kind. At that point, a partition in kind is not fungible, but you know, what the heck, they're down the road and they're no longer dealing with the LLC.
At that point, you're outside of the LLC Act.
Yes, you are.
It's already been distributed. And I agree, Michael, that, you know, the old adage, every piece of real estate's unique. But again, I read the statute that it's talking about a singular asset, not a set of assets. And so on that singular asset, you know, again, I'm having a hard time. If you distribute equal or proportionate interest to each person, everything should be fungible in some sense.
Yeah,
anyway.
If you read it like that, I think the statute would be nonsensical, because if you read it that there's other than, you know, maybe a human being, everything is dividable and fungible by having, you know, co-tenancy interests in that particular asset. Even a Van Gogh, you can own in a joint tenancy in common fashion.
Yes, please.
Yeah, I think that fungible is a pretty well-defined legal concept. I don't think it's going to trip people up too much, and I don't think that there's any chance real property would ever be held by a court to be fungible.
I agree.
So,
I think it may end up requiring, in effect, a sale of the real estate and distribution of the proceeds, rather than forcing a tenancy in common interest on someone.
Yeah, or, you know, if a tenancy in common interest, if a court does decide that's what needs to happen, then there will be a subsequent action for a partition,
right,
which is outside of this LLC Act context. So I think it's fine.
Okay.
So are we good?
Yes.
Okay, so D, yay. If a member or transferee becomes entitled to receive a distribution, the member or transferee has the status of and is entitled to all remedies available to a creditor of the limited liability company with respect to the distribution. However, the company's obligation to make a distribution is subject to offset for any amount owed to the company by a member or person disassociated as a member on account whose distribution was made. And I have highlighted that last however clause. I think it is consistent. And so the parallel part to the first sentence of 404D is section 63.225, right to distribution. When a member becomes entitled to receive a distribution, the member has a status of it is entitled to all remedies available to the creditor of the limited liability company with respect to the distribution. So that is actually identical, except there's some commas in Rilke, but not significant. So, and I think that probably the second sentence is probably fine too, even though I did not find a direct parallel to that. That may be that the direct parallel might be something that's in Article 5.
Yeah, Teresa, thoughts?
Sorry, I had to unmute there. I think that this makes sense the way that it's written to allow the company to do an offset. I mean, where this is going to come up is when you have a member or a transferee that is insolvent, or a bankruptcy trustee holding the membership interest as a transferee, and the company is going to distribute profits of $500, but the member still owed the company $1,000.
Mm-hmm.
What this means is the company doesn't have to pay that distribution until the company's been paid in full, because it's not otherwise going to be able to collect from that member or member's transferee. The bankruptcy trustees won't like it, but it's probably the right rule.
Yeah. Yeah, it makes sense to me. Anybody have any concerns about it? All right, hearing none, let's go with it.
Okay, so I think we're done with 404 for now.
Yep.
All right, 405 is limitations on distributions. And if you're following along on the side-by-side, it's on page 5 of the side-by-side. It's on page 92 of Rilke handout. This is mostly non-waivable. So this is mostly mandatory provisions. So what 405 says, a limited liability company may not make a distribution, including a distribution under 707, if after the distribution, the company would not be able to pay its debts as it becomes due in the ordinary course of the company's activities and affairs, or the company's total assets would be less than the sum of its total liabilities plus the amount that would be needed if the company were to be dissolved and wound up at the time of distribution to satisfy the preferential rights upon dissolution and winding up of the members and transferees whose preferential rights are superior to the rights of persons receiving the distribution. Okay, so this is, the parallel provision is 63.229. And what I noted was it's just sort of framed differently, which I doubt is terribly important. So what Rilke says is the limited liability company may not make a distribution. What ORS says, a distribution may be made only if, after giving effect to the distribution, in the judgment of members for a member managed limited liability company or the managers for a manager managed limited liability company, then it goes on to kind of the same sort of things. The limited liability company would be able to pay its debts. Slight difference, instead of saying the company's total assets, it says the fair market value of the total assets would be less than the sum of the total liabilities. So just slight differences here. I do want to highlight, though, that the ORS is talking about in the judgment of the members. And there's something else later on, too, when we get to B, which is talking about how the determination of whether the distribution is allowed or not also sort of gets to the judgment of the members, or the beliefs of the members, and that's in the ORS, and that's not in RILCA. So should I go on to B so we can think about this all together?
Mm-hmm. Actually, I'll comment on the judgment of the members issue, and also the fair market value issue.
Mm-hmm.
I think RILCA is right on both of these points, and I think this is an improvement over Oregon law. With respect to not using the fair market value, but just using the word value, it's pretty customary for valuation fights to happen based on what the expectation of what the property is going to be used for is. So if you have a business that is expected to continue to be a going concern, then a fair market value basis makes a lot of sense. But if you are in a liquidation process intentionally, whether you're closing a division or whether you're liquidating the entire business or whatever, it does make sense to look at liquidation values under those circumstances. And that would be fair liquidation value, but it's not fair market value. Those are two very different things.
Well, they don't even talk about value at all. They just talk about total assets.
Right,
Which
and
sort
that
of
makes
implies
sense
value,
to me, because you would then have to have a determination in any dispute as to what the appropriate measure of value would be. But I think it's appropriate not to prejudge that issue and say it has to be fair market value, because it may not be fair market value that's the right value to look at. I really like getting rid of the phrase "in the judgment of the members," because if you've ever spent any great amount of time with companies that are swirling the drain and about to fail, their judgment is not usually very good about what is really going on. The vast majority of those folks become seriously in denial, and they don't do things that are objectively reasonable. And I don't think we should be deferring to the judgment of people who are in denial.
Well said.
On this issue, I'm fine with that. On this issue about getting rid of fair value, the context where I see that come up the most is in valuing closely held corporations or LLCs, other business entities, where fair market value, for example, will have reductions for
minority discounts.
Yes, minority discount, marketability discount, whereas fair value, you don't apply those discounts. And so often, you know, LLC can be a holding company for another LLC or multiple LLCs under it. In other words, that one of the assets of the LLC is another LLC. And I would think in that context, fair value may be, I haven't decided whether it's better to have fair value as compared to market or undefined value, but it may be an important distinction and change that we're making in that context.
And I actually think that using just value on its own is better in order to accomplish what you're talking about, because it does allow for the use of minority discounts in circumstances where that would be appropriate, but in other circumstances where it isn't going to matter, like you're not selling one interest separate from the others, then you don't have to consider that. So
okay, go ahead.
I think we should take a look at 405B2.
Yep, that's where I was going.
I think it puts some context around the conversation we're having, a fair valuation or other method that is reasonable under circumstances, which Teresa, I think you were making the very good point about the context is everything, and going concern versus a company that's circling the drain, I think this is an improvement where it really looks to a fair valuation, which is probably a different concept than fair value under existing Oregon law, but
right.
a reasonable objective standard under the circumstances, context.
Shall I read the provision then, Michael?
Yeah, please.
Okay, so 405B, a limited liability company may base a determination that a distribution is not prohibited under subsection A on 1, financial statements prepared on the basis of accounting practices and principles that are reasonable in the circumstances, or, as Michael is pointing out, 2, a fair valuation or other method that is reasonable under the circumstances. So the distinction, so that does bring in fair value. So I think there would be not much point in keeping it, the fair value concept that's in ORS. But the other thing that I want to bring up, and this may get to Teresa's point about whether the members or managers are going to be rational human beings at the point where their business is circling the drain. Because in ORS, and this is 63.229 B2A and B, members or managers of a limited liability company may base a determination that a distribution is not prohibited under subsection 1 of the section either on financial statements that the members or managers reasonably believe have been prepared on the basis of accounting practices and principles that are reasonable under the circumstances, or a fair valuation or other method that the members or managers reasonably believe is reasonable in the circumstances.
Yeah, and I want to get rid of this entire concept of their reasonable belief and their judgment, because that's not how it should be measured. It should be measured by reality, not by what people in denial think.
Yeah.
Okay.
Guys, I'm actually going to have to bounce here pretty quick, but I did want to direct people's attention to ORS 60.181, which is the corporate statute on distributions, which essentially mirrors RULCA's section 405. And I know there's quite a bit of Oregon corporate law interpreting this statute. And so I think actually adopting RULCA, given its consistency with the Oregon corporate statute on distributions, to provide more guidance in it.
And Cliff, I just want to point out that in the comment following 405, it says that both 405 and 406 were derived essentially from the Model Business Corporation Act, section 6.40, which is probably where the Oregon Corporation Act came from.
Yep. So.
Okay, thank you. Thank you. Bye. Okay, so I think that's it for B.
Mm-hmm.
So we could move on to C. Except as provided in E, the effect of a distribution under A is measured in the case of a distribution defined in section 102.4A as of the earlier of the date money or other property is transferred or debt is incurred by the limited liability company, or the date the person entitled to the distribution ceases to own the interest or right being acquired by the company in return for the distribution. 2, in the case of any other distribution of indebtedness, as of the date the indebtedness is distributed. And 3, in all other cases, as of the date the distribution is authorized, if the payment occurs not later than 120 days after that date, or B, the payment is made if the payment occurs more than 120 days after the distribution is authorized. And this is basically the same as C under ORS 63.229, which also refers to the 120 days and is, I think, very much similar. Really, and I think that D was pretty similar as well. I didn't note any significant differences. The one difference I noted was it doesn't appear that ORS has a parallel to paragraph E. And I should say that D in RULCA in 405D is parallel to paragraph 5. Let's see, I guess it's 5 of the Oregon statute.
I, for one, have no problem with E. I think it's reasonable.
Yeah,
I agree. I agree.
You know, you can fix a problem by just putting the appropriate language in the promissory note, for example.
Mm-hmm. Yeah, I mean, I think these provisions make sense, and I agree with Teresa that, you know, the idea of looking at valuation under the circumstances makes a lot of sense. You know, I don't have any concerns about the rest of the section. Does anybody have concerns they want to flag?
I just, I guess, wanted to note that 63-229 sub 3 didn't seem to have a analog in RULCA, and I didn't know. You know.
Actually, that may be very similar to E. Shall be disregarded. There's a recourse of this.
I think that's the case, because I think where this E is going to come up is when you're winding down an LLC and you've got members who are buying themselves out, and you're making promises to pay them over time for the amount that you owe them on their withdrawal. And you're looking at each periodic payment for purposes of insolvency as it becomes obligated to be paid, and not all at once at the outset. You don't have to include the entire liability when you first make that promise.
Right.
What it means is the member, if the company becomes insolvent, the member might not get everything they were promised, but that would be appropriate if the company became insolvent. So I think it's right.
Right.
Right to get rid of the current RS, you mean? The RULCA is right, you're saying?
I think RULCA is right, and I don't think it's much different than the current ORS, because I think it is similar to 63-229 sub 3.
Yeah.
Well, I mean, it's a little different though.
Yeah.
Because what it's talking about is if you've got essentially a non-recourse liability. So the limited liability company buys some property, and the creditor buys Blackacre, and the creditor lends money, non-recourse note on Blackacre for $300,000. Then at the time of the dissolution, the value of Blackacre is $500,000. So, oh no, I'm sorry, I should say that the other way around. Now it's $100,000.
Yeah.
You don't count the liability at 300, you only count it at 100 because the creditor couldn't get more than Blackacre, which is only worth 100. Does that sound right?
Yeah, I mean, I guess maybe it's really sort of a rule regarding how do you value the assets of the LLC.
Mm-hmm.
And, you know, maybe I find that it would be helpful to, like, for us to issue like a formal comment that the deletion of the words fair value as well as 229 sub 3 isn't an indication that we disagree with the principles there, but that those are just, they're not applicable in every single scenario, and where they are applicable, I would think that those principles would still govern.
Mm-hmm, mm-hmm.
I think what we would say is that the method of valuation should be determined by the purpose and the circumstances under which it's made, which may in some circumstances be fair valuation, but in other circumstances may be something different.
Well, that's where the reasonable under the circumstances gets to, right?
Yeah.
Yeah. So,
I mean, I have to say that I've read E many times, and every once in a while I think I understand it, but then I'm not sure. So I'm just going to read E, and I'll see if anyone can help me with that. A limited liability company's indebtedness, including indebtedness issued as a distribution, is not a liability if the terms of the indebtedness provide that payment of principal and interest is made only if and to the extent that payment of a distribution could then be made under this section. Ooh.
right. And so here's where the circumstance where that comes up. So you have an LLC that's on the rocks. Its financial prospects are uncertain. In other words, it's like every LLC right now, right? Under COVID-19. And they don't know if they're going to make it or not. They hope they will. They're making changes. They're trying to adapt, but they don't know if they're going to make it. But they have one member that wants out. And they've agreed to let that member out for a payment of $100,000. And it's going to be paid, you know, $25,000 at a time over the next 4 quarters. And so what this says is, if in your promise to your member, we'll buy you out, you'll give up your shares now, and we'll pay you $25,000 a quarter for the next 4 quarters, but only if we could do so under subparagraph A, which is only if we're not insolvent at the time, because we can't promise to pay you if we're insolvent, and the rest of us are all taking the risk this company's going to fail, and we don't want to pay you out and you get a whole bunch of money and then it fails and the rest of us are not left in the same boat. You need to be in the same boat as us, taking the same risk. And so they make that deal that in the agreement to make payments, the payments will only be made in the event the company's not going to make itself insolvent by making them. So what that means is, under subsection A, when you're looking at making a distribution in the second quarter, for example, and making the payment on the note in the second quarter to the other members of the LLC, that you don't have to include the entire $100,000 of the debt or the remaining $75,000 of the debt to determine the insolvency. You only look at it as if you are paying this quarter's payment. And the other payments in quarter 3 and quarter 4 for the other $50,000 are still up in the air. You might or might not ever make them. But as we're eking our way through this, difficult economic time, today in quarter 2, when we look at insolvency only considering the $25,000 we owe today, then that's okay, we can make that payment. And then we'll measure it again when we get to the next one. That makes a lot of sense to me.
That does make a lot of sense. Yeah, thank you. That does make a lot of sense. Just the way it was written is kind of like, we're going around in circles. Okay. So
we're okay with E, and then I flagged sub F because David and I are going to be talking about section 7.
707.
Yeah, so
Yeah,
Article 7. So I flagged
Cool.
704, 705, and 706.
Cool. Very good. Okay, so then shall we move on to 406, which is the last thing we're going to do today? And
yeah.
Hopefully might get through it. Who knows? Okay, 406, liability for improper distributions. This is non-waivable. It's on page 95. Except as provided in subsection B, if a member of a member-managed limited liability company or a manager of a manager-managed limited liability company consents to a distribution made in violation of section 405, and in consenting to the distribution fails to comply with section 409, the member or manager is personally liable for the amount of the distribution which exceeds the amount which could have been distributed without violation of 405. And that the parallel provision is in ORS is 63.235. And the distinction is that the ORS that has the last clause of that provision, in at least paragraph 1 of that provision, is it applies if it is established that the member or manager did not perform the member's or manager's duties in compliance with ORS 63.155. And I think that is a parallel to section 409, which we discussed in our last meeting,
right?
Which is the duties.
Yeah.
So seems to me this is good and works.
Yeah.
So
B,
to the extent the operating agreement of a member managed limited liability company expressly relieves a member of the authority and responsibility to consent to distributions and imposes that authority and responsibility on one or more other members, the liability stated in subsection A applies to the other members and not to the member that the operating agreement relieves of the authority and responsibility. That is not totally clear in ORS. I think it's probably a good idea. There is, so the next section is that it sort of kind of relates to it, which is the, I want to look at ORS, the thing that I've highlighted in ORS, which is 63.235 3A, which is the impleading part. So paragraph D of 406 refers to the who you can implead, right, and get a right of contribution. And so I think if you read that section together with ORS, sorry, I have to keep looking at it because I can't remember it. 63.235 3A.
Right.
Other members or managers who voted for or assented to the distribution in violation of this section. So can be impleaded and you can compel contribution from those members who assented to the contribution. So that sort of seems to me to be similar to, all right, if you didn't vote for it, you can make the people who voted for it be liable. It's not quite the same as relieving the member prospectively from liability, but it's kind of a similar idea. And I think that the ROLCA is a better solution than having to get sued even though you didn't vote for it and then implead the people who did vote for it.
Yeah, I agree. I mean, essentially what we've got here is 63.235 with the addition of the subsection B, right?
Yeah. Yep. Which I think, and subsection B, I think makes a lot of sense. And it's got the same statute of limitations, 2-year statute of limitations, that the action is barred unless it's commenced no later than 2 years after the distribution. And the comments say this is derived from the Model Business Corporation Act. And so it's a default provision other than that the duties can be revised by the operating agreement under section 409, which, as I said, I think we covered last meeting.
Any debate about this section or concerns?
No.
Yeah.
I think it's right.
Yeah. Good. Excellent. Good job, guys.
All right.
Okay, so that was the last section that you were covering, right, Roberta?
That's right.
Okay, and so I'm going to make a note that we're generally okay with this.
Yeah, I have.
So,
oh, who was talking?
Sandy,
Sorry.
I think?
Sandy, I have consensus notes on pretty much on that section.
Okay, so next time, so when is our next meeting, Sandy?
June 10th is the next meeting. You all should have a calendar invite for that one.
Okay, I'd like to get July tentatively on the calendar for folks. Let me pull up our calendars. June, July. I mean, who knows what's going to be going on in July?
Much of this, I think.
Ugh, hope not. You saw that Germany is having to shut down again. Ridiculous.
No, I hadn't seen that yet.
Yeah, there's a thing that just came out on WAPO. So
South Korea shut down again too.
Yeah, it's ridiculous. Well, so we have a business law section EC meeting on the 8th. What does the 8th look like for people?
I am not available in the morning on the 8th.
I'm not available either.
Okay, what about the 9th?
Yep, good.
I'm okay.
It's fine.
That works.
So we set the morning of the 9th then?
Yep.
Mm-hmm.
Okay. Sandy, you're gonna send out a thing?
I will.
Okay. And so for purposes of the next meeting, which is June 10th, we'll follow up on that one legislative history question and brief everybody, but we'll plan to start with Mosen on 410. And then to the extent that anybody has any concerns about anything through Article 4, shoot me and Sandy an email before then. And because I just want to make sure that we're putting a pin in what we've got so far. And then Teresa, you'll be ready to go forward with Article 5.
Hey, Valerie,
Yes, sir.
on the agenda is check back on the questions from Articles 1 through 3, and Sandy attached a long memo of them. At some point, are we going to go do those?
I just did that in case we ended really early today, but I'm going to keep adding to that list. But that's what I came up with of the clear questions so far. But I'm going to continue to add to that list.
But how far out do we want to get before we go back to those?
That's what. So maybe everybody can take a look at that, and we'll add that to the agenda as a pre-Article 5 item for next session, if that makes sense. Because I just want to make sure that we're not going to have an enormous list of things to resolve when we get to the end of the act.
And
good idea.
And also, just for everyone's sake, when I was putting that together, I did not include all the questions that need to go directly to Legislative Council, because those are really particular to Legislative Council, and we'll work directly with them. And a lot of those were, and Jamie, if you're on the phone, and you and Ruth, a lot of those questions were pertaining directly to Secretary of State, because I think there were meetings where either neither of you could be there, or they were just outstanding questions.
Yeah, so Sandy and Jamie, can we schedule just an offline touch base?
I'm fine with that.
Sure.
Before our next meeting? Okay, so we'll reach out separately, Jamie, and get something on the calendar.
Okay.
I have another meeting in 10 minutes, so I'm going to go and
yes,
see what I can eat.
Really appreciate it. Thank you again for covering all the stuff. So yeah, no, I think we're in good shape. Thank you all very much. Really appreciate it. It's a productive meeting.
Yeah, it was. Thank you, everyone. And I'll send out the schedule for July soon, and the June one you already have.
Great. Thank you so much, everybody. Have a great day.
Sounds good.
Thanks.
Bye-bye.
Bye.